Hello, everyone. For folks joining, we'll get started in about 1 minute. Hello, everyone, and welcome to the Environmental Law Institute's event, The Future of Administrative Law, the Loper, Bright, and Relentless Cases Potential Impact. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. We have a wonderful program in store for all of you today, and we're so excited that you've joined us this afternoon for it. I want to take a moment to thank our spectacular lineup of speakers for taking the time to join us. Today's event will be recorded and posted to the ELI website for members to view later. So if you're an ELI member, check back to the event webpage in a few business days to find the recording. If you'd like to become an ELI member, you can find all of that information on eli.org. We will be taking audience questions at the end of today's program, so please feel free to put your questions in Zoom's Q&A box as soon as you think of them. There's no need to wait until the end of the program. While the chat will also be open for you to post observations throughout the webinar, please put any questions that you wish for our speakers to address in the Q&A box rather than the chat. I'll now go ahead and turn things over to today's moderator, Jordan Diamond. Jordan has been the president of ELI since January 1st, 2022. Previously, Jordan was the executive director of UC Berkeley's Center for Law, Energy, and the Environment. Jordan also co-directed the Law of the Sea Institute at UC Berkeley from 2018 through 2023. And from 2018 through 2023, she served on the California Ocean Protection Council. Jordan, I'll hand things over to you. Thank you so much.
Thanks, Madison. So thank you to you and Sarah for setting up today's webinar. And I want to echo the welcome to everyone joining us today. As Madison said, I'm Jordan Diamond, president of the Environmental Law Institute, and I'm greatly looking forward to today's conversation and happy that you all have joined us for it. For those who are new to ELI, we are an internationally recognized nonpartisan research and education center. We work on strengthening environmental protection, but improving law and governance both domestically and worldwide. If you want to learn more, please check out our programs at www.eli.org. And if you're interested in becoming a member and having access to more events like today's, please reach out to Renee West. Renee's email address is west@eli.org. So back to today's conversation. Today, our discussion will center on the potential impacts of the Supreme Court's upcoming decision in Loper Bright Enterprises versus Raimundo and the tandem case of Relentless versus Department of Commerce. Oral argument was heard on these cases just 2 weeks ago on January 17th, and the ruling should come down before the end of the court's term in June. The cases themselves involve fisheries law, but are garnering a great deal of attention for their potentially much broader impacts on the field of administrative law, including specifically the potential impacts on the long-standing doctrine of Chevron deference. So today we are thrilled to have an exceptional panel with us to discuss the case. To our speakers, echoing Madison again, thank you so very much for taking the time to lead this conversation today. Before we begin the panel and I introduce the speakers more clearly, I want to take a moment to step back and provide a bit of context for those who have heard that this may be an important decision, but aren't entirely clear on why. I'll give a bit of background on the case itself and then the broad strokes of why there is so much attention. So the original case of Loper Bright versus Raimundo stemmed from implementation of part of the Magnuson-Stevens Fishery Conservation and Management Act, which since the mid-1970s has provided the foundation of the federal framework for managing fisheries. In the 1990s, an amendment to the act declared that data collection is essential, and the fishery management plans may require outside observers to be on board a vessel for data collection purposes to help ensure the healthy conservation of the fishery. For certain fisheries, Congress expressly stated that industry would cover the associated costs. For most, it was silent on this payment issue. Now, most people probably haven't heard much about the Federal Fisheries Observer Program unless you're involved in fisheries policy before these cases, although these provisions have been on the books and have been used for over 20 years. That all changed when in 2020, the New England Fishery Management Council made final a rule requiring regulated Atlantic herring fishing vessels to pay for third-party observers to be on board. So the rule divided the costs between the agency and vessel operators with provisions for waivers, exemptions, or alternatives to offset some or all of the costs. The rule was met with pushback. So a group of New Jersey-based herring fishermen filed suit challenging the rule. At the district court level, the presiding judge upheld the regulation, finding clear statutory authorization at what we call step 1 of the familiar Chevron test regarding agency deference. At the DC Circuit, 2 judges found the statute ambiguous, but upheld the regulation as a reasonable agency interpretation under Chevron Step 2. So both courts applied the Chevron framework, which has been a core element of administrative law since the mid-'80s. However, one DC Circuit judge dissented and did so arguing that statutory silence shouldn't be a reason for judges to apply Chevron deference, and also suggesting that the test itself had potentially outlived its usefulness. So this led to the fishermen appealing their case to the Supreme Court. The Fisheries Observer Program at issue was actually discontinued last spring, citing a lack of funds to cover its costs. But last May, the court granted review in the Loper case. And they did so not on the narrow issue of whether the Magnuson-Stevens Act implicitly grants the National Marine Fisheries Service the authority to require domestic vessels to pay for onboard monitors, but rather on a much broader question. Quote, whether the court should overrule Chevron or at least clarify that statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute does not constitute an ambiguity requiring deference to the agency. Now, because Justice Jackson had participated in oral argument when the case was before the DC Circuit, though she didn't participate in that decision, she recused from hearing Loper. So last October, the court announced it would consider the case in tandem with another challenge to the Fisheries Service rule, Relentless versus Department of Commerce. Since that case is on appeal from the First Circuit, Justice Jackson isn't recused from it. So a full bench of 9 justices heard oral argument on January 17th for over 3 hours and will be involved in the decision issued by the end of June. And the matter at issue, the matter on which the Supreme Court has granted review, is not fees for elements of fisheries management programs, but rather the future of the Chevron doctrine and its role in rulemaking writ large. So although the question on which cert was granted included the lesser question of Chevron's role when a statute is silent, the parties to the case have focused their arguments more on the broader question of whether Chevron should be entirely overruled. Okay, so with that as oriented context, we will now turn to our panel of experts for discussion. Our format today is fairly simple. We'll start with a few moments of opening comments from each of our speakers. I'll then take the moderator's privilege and ask a few questions to spur dialogue amongst them. And then we'll have ample time for Q&A with you, the audience. And for that, just to repeat what Madison already mentioned, please note that you are welcome to submit questions anytime through the Q&A box and through the Zoom controls. Please don't feel obliged to wait until the Q&A section. You can submit those questions anytime. If they're answered before we get to the Q&A section, that's fine. We can easily skip over them. So please don't feel you need to wait there. And then, of course, we will close no later than the 90 minute event. So with that, it is now my great pleasure to introduce our first panelist, David Donecker. David is a senior federal strategist in climate and energy at Natural Resources Defense Council, where he has been at the forefront of their work on air pollution and global climate change since 1978, whether it be helping formulate the Montreal Protocol or amending the Clean Air Act or taking a break from NRDC to serve at CEQ and EPA. His fuller biography is linked on the event announcement, and I promised him I wouldn't read all of it. But for today's purposes, I would be remiss if I did not highlight that David was one of the NRDC lawyers that argued Chevron v. NRDC in 1984, which is why we are particularly delighted to have him here today to walk us through that salient case, the development of the so-called Chevron deference test, and the effects on the administrative state for the last 40 years. So David, thank you for being here, and the mic is now yours.
Thank you for having me, and I would be remiss if I didn't mention that my first job in Washington was with ELI in 1978, before I went to NRDC. Well, I went to NRDC, and the Reagan administration came in and began to reverse prior EPA regulations to implement the Clean Air Act, including one of the earliest ones was a provision that required the most advanced emission controls to be put on industrial projects, new industrial projects that were built in the dirtiest areas of the country. And there's this elaborate superstructure of requirements that a stationary source, a major new stationary source built in such an area, had to meet. So the clever folks on the other side thought that the simplest way to repeal all these requirements, which Congress had just enacted in 1977, would be to change the definition of stationary source, the term to which all these requirements apply. And I won't go into all the this and that's of the bubble concept, but the alternative definition was one that effectively exempted 90% of the industrial projects that would otherwise have been subject to these pollution control requirements from them. So NRDC sued. The suit was named NRDC versus Gorsuch. Anne Gorsuch, the mother of the current justice, was the EPA administrator at the time. And we won in the DC circuit, but we won on a screwy basis. There had been a total of 3 cases, this being the third one, involving the definition of stationary source in 3 different programs of the Clean Air Act. And instead of adopting our position that the terms were unambiguous and clear and couldn't be defined the way the Reagan administration had done, the court had developed in 3 cases a decision rule which they called the law of this court, or the law of the circuit, that the straight ahead definition was required wherever the program was intended to reduce pollution, but it was allowed, the weaker definition was allowed in any program which was intended merely to limit how much worse the pollution got. So another judge whose name you've heard of, Judge Ginsburg, ruled in our favor in this case because this was a program intended to clean up the dirtiest areas of the country. Well, the administration appealed, and even though I was like 32 years old, and said, well, who's going to do this? And my colleagues said, well, you did it so far, you should do this. And I said, gulp, and went on ahead. And we argued, although we weren't framing it in these step 1, step 2 terms, we argued this statute is absolutely clear, and there's no wiggle room for the kind of policymaking that the administration has done here. The papers of Justice Blackmun, which came out like 15 years later after he died, show that we actually had a split. We had a split in the justices. There were only 6, so there were 7 who participated in the argument. Marshall was sick. Rehnquist got up and walked out. I later wondered whether it was because he had back troubles. And anyway, he didn't participate. And then Sandra Day O'Connor recused herself, having, between argument and decision, inherited stock in some of the many companies that were lined up to support the Reagan administration in this rollback. And the ultimate decision from Justice Stevens was that they were not convinced that we had shown the statute to be unambiguous. And then he went on to rebuke the DC Circuit, say, you know, when you have a statute, or Congress often needs to or can't fill in all the details. So they need to pass statutes that enlist the assistance of the regulatory agencies, which report to the president, and of course report to Congress too. And that these politically accountable branches should be making the policy decisions. You judges on the DC Circuit have no business making up this policy-based rule that would control the outcome. So stop that. And in cases where the statute is clear, you must use all the statutory tools of construction to determine whether it's clear. And if you determine it is, then enforce it. But if you determine that Congress has left some space, some ambiguity, and he particularly, he mentioned both deliberately and by silence, then it was the job of the lower court judges or Supreme Court judges, justices too, to defer to the policy choice of the agency if it was a reasonable one. So it was not carte blanche. There are examples we can cite of situations of ambiguity where the interpretation is just wacko and has itself been disallowed as impermissible or unreasonable. But basically, the proposition was that the policy decisions should be made by the politically accountable branches and not by unelected judges with no constituency. Now, this view was immediately embraced by a lot of conservative judges. Bork, Scalia was a big champ. A whole bunch of the other DC Circuit conservatives, as well as the liberals. And they saw it initially as and I think rightly, as a neutral proposition. And it took over at the appellate court level in particular as a convenient rubric for addressing whether challenges to administrative agencies' decisions should be overruled because they're flatly illegal and unambiguously illegal, or whether they should be upheld because there's several reasonable interpretations and the agency has chosen one, and it's not up to the court to decide whether it prefers the one that the court chose, that the agency chose. So that's became the rule for the last 40 years. It's actually a restatement of the prior rule, which Justice Stevens always maintained he was not making any new law. He was restating the approach that the Supreme Court and other courts had used to interpret, to review agency interpretations under the statutes Congress had assigned to them for 100 years or more before that. So there's really 140, 150 years of precedent here at stake. Now, conservatives began to get unhappy with this. And I would say the business elements more than the intellectual conservatives first. When the Clinton administration came along, and later Obama, and now Biden, and you start using the flex that Congress has left in these laws to do more rather than to do less. There's been now 10 years or so of a concerted effort to gussy up this basic notion that the administrative agencies shouldn't have this freedom to do more rather than less in statutory and constitutional terms. That maybe others will talk about, the argument that this is inconsistent with the Administrative Procedure Act. I don't think it is. Whether that's an unconstitutional devolution of law interpreting from the courts to the agencies. But anyway, that's the way the argument went. Now, Scalia was a big defender of this, and sometimes he ruled in favor of or didn't object to some of these, let's call them do more decisions. Sometimes he did, but he would say, he would not generally say, he never challenged his own adherence to the Chevron framework, to my knowledge. There is some apocryphal storytelling that near the end of his life, like just before he died, he was changing his mind. But I'm not aware of writings that indicate that. We can talk a little bit later about how the major question doctrine emerged as an exception. But I think maybe I've used up my time, and more than happy to explore this stuff in dialogue with my colleagues and then Q&A with you.
Fantastic.
Let me say one more thing, and I forgot my best joke, which is that my career would be bookended by the birth and death of the Chevron doctrine, and I'll be on the losing side both times.
Thank you very much, David, for that enriching and necessary context for contemplating the effects of the upcoming decisions. It is now a pleasure to turn to Steph Tai. Steph is a professor of law at the University of Wisconsin at Madison and Associate Dean for Education and Faculty Affairs at the Nelson Institute for Environmental Studies. After being raised by two chemists, their research now focuses on the interactions between environmental and health sciences and administrative law. They have taught at numerous highly respected academic institutions, have published widely in leading journals, and actively represent amici in federal circuit and Supreme Court cases. As before, their full bio is linked on the event announcement. Madison circulated that in the chat, Madison circulated that in the chat, so you can click there for more bio information. But for the moment, Steph, thank you so much for joining us today to discuss the potential repercussions of the upcoming decision on the use of science.
Thank you for having me. One of the things, and I wanted to mention this, it struck me as I was listening to the oral arguments in Loper, Bright, and Relentless, was the idea that Congress had intended a sort of best interpretation of the statute, especially in areas where they were not necessarily knowledgeable. One of the things that I have written amicus briefs on is just explaining the current state of the science to the Supreme Court. One of the issues with that, right, is that, for example, Congress doesn't have, an extensive scientific staff, right? So you could imagine in other cases, not necessarily this one where the issue is whether or not observers would have to be paid for by ships, but in other areas, right? Certain types of things, like does something count as a pollutant that endangers public health? It's not like Congress had in mind X, Y, Z pollutants as it was drafting the statute. One, because it doesn't necessarily and cannot necessarily have that sort of scientific background to develop everything in the future. And two, because regulations have to evolve, right? There's a lot of things that we are now understanding, for example, PFAS, which is in our nation's waters, that were not necessarily contemplated by Congress at the time that it was passing its various pollution control statutes. And so the expectation, right, that courts can somehow discern what Congress meant within the language of an act that sort of encompasses both areas outside of its scientific expertise, and it also encompasses scientific developments that were not available at the time that Congress passed the statutes, seems crazy to me, right? And the idea that courts can evaluate these kinds of scientific determinations itself is also somewhat problematic. One of the ways in which courts actually receive science is through amicus briefs. But as many of us know, in terms of amicus brief offerings, the amicus briefs are usually in favor of one side or the other. And there's a potential for sort of cherry pick science with a sort of acontextuality that doesn't represent the overall views of the scientific community. In contrast, right, agencies do have some types of mechanisms to sort of search the entire scientific literature. Now, they might fail to do so, in which case there can be challenges based upon the sort of arbitrary and capriciousness of the agency's decision. But the idea that these types of terms, every single term in the statute, fully encompasses all of scientific knowledge and developing scientific knowledge is kind of remarkable. I point to some of the sort of references to Skidmore that was made within the oral arguments. So Skidmore is the doctrine that, and many of the justices pushed back against characterizing Skidmore as Skidmore deference, but whatever we call it, the Skidmore doctrine is that an agency's decision deserves some weight based upon its persuasive power and also based upon its consistency. And some of the justices, as well as the advocates, argued that consistency is something that should be prized. That's not necessarily the case. Again, scientific developments often find that certain types of materials that were considered harmless at the time, for example, the ozone depleting compounds that were used as refrigerants, can be found not to be. And so consistency is not actually reflective of the state of scientific development. And so there's a tension with the at least core application of Skidmore. Again, we'll leave it to the court to decide how to characterize that, and actually sort of scientific developments writ large. So that's the sort of science end of things. Now, I also wanted to bring up, since I'm at the University of Wisconsin, that I am in a state which has gotten rid of deference at, period. And this was brought up in the oral arguments saying that, many states have experimented with getting rid of Chevron deference or Chevron-like deference, and they've been fine. I would not characterize it as being fine. The experience with Wisconsin, and I'll explain what the experience is suggested that agencies have, both for the reasons of the overturning of deference, but also for other reasons, been more reluctant to pass regulations. The background is this. So in 2018, the Supreme Court of Wisconsin, in a case called Tetra Tech, got rid of deference. Before, Wisconsin courts have historically, I think for over 50 years, held that an agency's interpretation of law gets what's called great weight deference if the following conditions were met. One, the agency was charged by the legislature with a duty of administrating the law being interpreted. Two, the interpretation is one of longstanding. Three, the agency employed its expertise or specialized knowledge. And four, the agency's interpretation will provide uniformity and consistency. So kind of a mixture of Chevron and Skidmore, whether or not you call it deference or not. If those conditions were met, great weight deference was required that the courts defer to an agency's interpretation so long it was reasonable, which is a fairly low burden for the agency. And so what happened then was in Tetra Tech, the Supreme Court overruled that. They overruled their entire history of giving great weight deference. And now what is in place is what's called due weight deference, which looks a lot more just like Skidmore, which is just a matter of persuasiveness rather than deference. And that too was enshrined into law in 2018. Now, again, this was brought up in the Loper, Bright, and Relentless arguments of the experience with states getting rid of any kind of deference, and they were saying it's just fine. It's just fine if you don't want regulation. And the undertone of this is that, yes, it's just fine because maybe we don't like regulation. That has been the case with this. And so to the extent of what you characterize as just fine in a post-Chevron world is itself a sort of policy decision. So I'll end that to sort of time for more Q&A.
Thank you, Steph. Appreciate those insights and the potential ripple effects of the decision. And now I'm very happy to turn third to Holly Doremus. Holly is the Associate Dean of Faculty Development and Research, Professor of Environmental Regulation, and Director of the Law of the Sea Institute at the UC Berkeley School of Law, where she teaches courses ranging from ocean and coastal law to environmental law and policy, from water law to biodiversity law. I've taken several of those classes from her. And with a background, including a PhD in the life sciences, she brings a deep commitment to interdisciplinary teaching and scholarship to her work and research. I had the pleasure of working with Holly for many years at UC Berkeley. And Holly, thank you so much for joining us today to discuss the upcoming decision and how it may affect lawmaking and rulemaking in perpetuity.
Thanks, Jordan. And it's a pleasure to be here with such distinguished co-panelists, and we'll see if I have anything real to add. I guess I want to make one overarching point, which is that there's a reason why Chevron has been the source of a lot of commentary and conflict since 1984. And before that, there was a lot of commentary and conflict about how courts and agencies should relate to one another. This case is not going to change that. There is going to continue to be commentary and conflict and a lot of litigation about what agencies are permitted to do and how courts should oversee what agencies are doing. Actually, it has long been a kind of joke in academia that anybody who does any work relating to administrative law has to write at least one article that is centered on Chevron and its interpretation and what it means. And so maybe once we get a decision in Loper Bright here, we'll have a new version that everyone will have to write their Loper Bright article. I think the reason that there's been so much room for discussion and so much ongoing conflict is that there are two key tensions, two key issues that are essentially impossible to resolve. The first is, what's the appropriate institutional relationships between Congress, the courts, and administrative agencies? The petitioners here, the lawyers representing the fishermen, have made a really concerted effort, and they've been helped along by some of the justices in that, to pose the question here as, if there's difficulty interpreting the statute, should that mean that the government wins versus the individuals? And to say, why should we assume that the government gets deference rather than individual liberty getting deference? But of course, it's important to remember that's not the question in this case, or in any case about interpreting, about who gets to interpret statutes. The question is, does the agency get the first crack, and how much are we going to care about what they think this statute means, rather than do the courts get the first crack at saying, what does the statute mean? So it's an intergovernmental conflict rather than being about government versus individual liberty. The second key tension that is hard to resolve is, at what pace should the law change? How much should we like stability versus change, and who should be in control of how rapidly the law changes? And there are at least three reasons why we should want the law to be able to change, and why we should be skeptical of Congress being the right institution to keep up with the need for change. Policy whiplash is a real problem, and it's a serious problem these days. And when I say policy whiplash, I mean the tendency of the new presidential administration to spend a lot of time and resources changing the rules that the last presidential administration had put a lot of time and effort into creating. That's spinning our wheels. It can make it very difficult for regulated parties or others to understand what the law is and to govern their actions accordingly. But that doesn't mean that the law should never change, right? The facts on the ground change. We certainly know that, those of us who are interested in environmental law and have watched as climate change has become increasingly important and has more and more obvious impacts on the world. In addition, knowledge changes. As Steph points out, we learn things from science over time, and we want the law to be able to respond to that. And the third thing is that our social values change. over time. And we also want the law to respond to that. And the real question of this case, and also raised by all the other ways that the people pushing this case are pushing back on administrative agency action, is who should get to respond. And their answer is Congress should get to respond. And I would say that's absolutely desirable. And we all remember that being in sort of cartoon civics, the way that we do things. Congress is our key democratic institution. But if we look at Congress these days, it's entirely incapable of responding to the current rate of change. I'll stop there and look forward to the discussion.
Thank you very much, Polly. Really appreciate your thoughts on what may result here. So finally, last but certainly not least, it is a pleasure to introduce Kevin Poloncarz, partner at Covington and Burling, where he co-chairs the firm's environmental and energy practice group, the energy industry group, and the ESG practice. And in addition to his leading practice and array of accolades, including his prior service on ELI's board of directors, for which we are most grateful, in addition to all of that, Kevin also represented a coalition of major power companies in the West Virginia v. EPA decision that was issued in 2022, relevant to parts of today's discussion. So Kevin, thank you very much for taking the time to join the conversation today.
Thanks for having me. I thought I would start by just reflecting upon an exchange I had with Professor Lisa Heinzerling, Jordan, last time we convened when we were discussing West Virginia versus EPA. And I was trying to illuminate the daylight between the majority's opinion there and Gorsuch's concurrence. And just to be brief and to summarize, in West Virginia, the court found and named for the first time in a majority opinion this major questions doctrine. And the court said that even where an interpretation that an agency has proffered of a statute is plausible, we won't defer to the agency's interpretation if it is a question of vast political significance or economic significance, if it involves this grab bag of factors of if it's something that's controversial, if it's a long existing statute that's being interpreted in new ways. Essentially, the court opened the door to say that this is, I think as David described it, an exception from Chevron, and an instance in which we would not defer to an agency's action. Importantly, in that decision, in the majority's decision, they announced that this is rooted in the separation of powers. And so that took these questions of what we thought we were doing, statutory interpretation, looking at the statute, using canons of construction, and figuring out what the law is, it implicated these constitutional dimensions, that this is really about the separation of powers. But what Gorsuch's concurrence really talked about, and he spent his energy and time on, is saying that, yes, we agree that we shouldn't be deferring to agencies on tough questions like this. And he was really inflecting this non-delegation principle that this long, we thought dormant non-delegation doctrine that Congress can't possibly delegate certain decisions to agencies without an intelligible principle. That doctrine had been long not believed by most to not really exist for much of the century, but it's having a resurgence these days, and it was represented most acutely to me during the argument in Loper, Bright, and Relentless. And so when I tried to say that, Gorsuch didn't get this out of West Virginia, he just got that statement that this is rooted in the separation of powers, Professor Heinzerling cut me off and made very clear that no, the major questions doctrine is about non-delegation. Now, I won't go that far, but what I will say that became abundantly clear during the oral argument in this case is there is a belief among a number of justices on the court that this isn't about just pure statutory construction. This isn't the world we were living in when Scalia said, you look at the text, you start with the text, and you end with the text. That this is really about what is constitutional under Article 3 and what is the appropriate role of judges. And in the court's mind, in the mind of many of the justices on the court, it is an abdication of judicial responsibility to defer to an agency's interpretation. That Article 3 says judges decide the law. The APA says that judges decide questions of law, constitutional, statutory interpretation, and that means de novo review. On the other side is Justice Kagan, who truly is the intellectual heft on the left of the court these days, saying that that is not a doctrine of judicial humility. That is a doctrine that is the opposite of judicial restraint, for judges to presuppose upon themselves the prerogative of deciding what the statute means. And where it leaves me, what was most interesting in the argument is that this implicit delegation that Congress leaves these interstices, and that is the job of the executive branches that have to fill those interstices to figure out how to make it up, how to implement it, how to do it on the ground and make it most enforceable, that is at risk, and in this case, of being pronounced unconstitutional in some respects. I think what Gorsuch said in the argument is that this implied delegation theory is a fiction, and that there is nothing more offensive to the idea that Congress must deliver an intelligible principle to agencies than the idea of ambiguity. And his theory for that is that if he says that ambiguity is the tool of Congress when they can't get agreement on things, when they can't do the hard work of legislating that's required to come up with a compromise. He says what that lawmaker will do is they say, I know I have a friend in the executive who will discharge this law if I write it ambiguously to suit my ends. I don't really believe that. So to what Steph is saying, Congress can't write laws that presuppose all the facts that are going to change. And the one example, putting it beyond the world of environmental law that Justice Kagan used, which I thought was very illuminating during oral argument, is AI. She said that that's likely to be the next big area where Congress has to legislate. And how could they anticipate all the contours and problems and permutations of things that are going to come up when they try to draft legislation that delivers to some existing agency or some new agency principles on how to regulate this new space that's quickly evolving? I mean, it's no coincidence that many of these cases arise in environmental law because we have these old statutes that serve purposes that have changed over time. But that really worries me if Congress is going to be in the business of only legislating if they can be abundantly clear and not legislating in a way that anticipates changes that will occur. And at that, I'll close up. Jordan.
Thank you very much, Kevin. I appreciate your comments. Thank you all for those opening summaries. We're now going to turn, I'm going to take a little bit of the moderator's prerogative and pose some general questions to stimulate dialogue amongst all of you. So welcome everyone to comment on these. So first, we might take a step back and look, and I might softly highlight that maybe one of our professors will want to take a first stab at this. This case centers on the question of deference, which is at least 40 years old. If you're just looking at kind of the Chevron doctrine, I'd like to ask this group to comment on the role of precedent in U.S. law and how this case reflects or affects kind of your perception of that.
I don't know. Jordan sort of said one of the professors might start us out. So I don't know well, I do know that I'm definitely not the best person to speak to this, but I will say one thing, which is that in this circumstance where we're talking about what do courts do, what does Congress do, who gets to authorize what from agencies and how clear do they have to be, I actually think the role of precedent is at its most important there, at least from my perspective, because Congress for 40 years has been legislating in the shadow of Chevron. And it has never said, Congress, of course, is free to overrule things like Chevron, which are just about what do statutes mean and how should they be interpreted. And to go back now and to say to Congress, well, you've written a variety of statutes believing that you could delegate to the agencies and that you had, by using broad terms and so forth. And then to say, oh, now we're going to say that that statute never had that impact, that seems to me quite problematic. And if they're going to go where Kevin suggested Justice Gorsuch at least would probably like to go and say, well, Congress, you don't have the constitutional power to do that. That's one thing. But if what they're going to say is you do have the constitutional power to delegate, but you had to be super clear about it in 1980, we hadn't told you that then, or sorry, in 1986 or whatever, we had told you didn't have to be that clear, but actually you do, and you had to be that clear in the 1970s, we're telling you now. That's super problematic. And given the current dysfunction in Congress, they have no way to respond.
Thank you, Holly. I think Steph, you had unmuted, so maybe we'll go Steph and then over to David.
Oh no, I think Holly's points are really great. I just wanted to point out that I guess the eagerness at which the Supreme Court wants to at least revisit precedent, if not overturn precedent, is really indicated by the grant of cert on this case itself, right? There's not actually observer fees at issue anymore. And so to me, again, that sort of suggests how eager they are to revisit precedent, whether for good or bad.
David?
I'm just going to reflect a bit more on some of the good things that the panelists have said about the legislative process. We have a legislature, and by the way, I think it would be wrong, and it would be a bad tactic to say, well, administrative deference to administrative authority is needed because Congress can't name post offices anymore. So what I think back to is let's call them the great Congresses. There are periods of in our history, and I'm not an American historian, but at least familiar with some of them, when Congress was really very on the ball. They were active. They were doing things of great moment. The Progressive Era is one. The New Deal era is another. And although I don't think it has a recognized name, the era of the late 60s through the 70s is another one. And you had a bipartisan agreement. Let's just focus on the 60s and 70s, that the post-war world had gotten horrendously air polluted and water polluted, and we needed stronger responses. Oh, also that the national economy had the size of companies and other actors in the national economy had outweighed the capacity of states to handle these problems. So the federal government's capacity to they believed in the federal government's capacity to solve these problems. They also knew, as Steph has said, that some of them are insanely complicated. And they also, and the one other thing they knew is, since you could think of the Congress as, even the great Congresses, as jugglers, they've got so much to do that they can only deal with any given statute, roughly speaking, once a decade. So, in the good old days, they would review the Clean Air Act once every 10 years or so. And then they would go back and review administrative decisions and change some of them, not endorse all of them, some of them flat out reversed, new powers added, new problems recognized, and so on. But the original idea was, in 1970, we've got 5 air pollutants in front of us that we know about. but we know there's going to be a lot more. And we've got a couple of industries that we're familiar with that we've had extensive hearings on, the auto industry in particular, and so on. But we know there's hundreds of industries that are emitting these dozens and dozens of pollutants. So we have to enlist, I don't like to call it delegate, we have to enlist the capacity of the agencies to help us with the problems of bandwidth and expertise and foresight that limit our ability to, write the perfect statute, either with perfect foresight 20 years ahead, or to be able to deal with this year by year by year as things change. So we need help. And this has been true since 1789. And the world just keeps getting more complicated and throwing more complicated problems at us. So if we lose that capacity that Kevin was referring to, that Congress can delegate to agencies in this way to help fill things out. In other words, and Gorsuch has used the term that it's okay for Congress to tell agencies to fill up the details, but if the definition of filling up the details is so cramped that you can't, that there's no policy content that's available to the agencies. In other words, take a term like the best system of emission reduction. That's going to be different for 60, 80 industries to which EPA has applied it. You couldn't possibly have a functioning government that meets today's challenges if it has to legislate at the hyper specific level that Gorsuch's writings suggest. And one other thing I mentioned, which I also thought was ironic in the argument, in the COVID cases and in the West Virginia case, Gorsuch had emphasized in his concurrences that all this was being done to protect the liberty of the people who would be regulated. Not a word about the liberty of the people who were the beneficiaries of the regulation. In the case of COVID, it's just so striking. The liberty of the regulated taking primacy over the life and death and deprivation of liberty of millions of Americans. That should weigh more heavily. And the whole purpose of the Clean Air Act or any pollution statute, and also any economic regulatory statute like investor protection laws, is to protect a class of beneficiaries from wrongdoing by a class of wrongdoers. And it's not always so clear what the right answer is. What's the right amount of risk that should be, or the right amount of data that it would take to justify pulling a product off the market in order to protect somebody's health versus the economic burden. Those kinds of questions need to be dealt with at the top level by Congress, but they need to be able to enlist the agencies to put that into practice at the sort of medium level, above pure fact finding. But there has to be some capacity in the executive branch to balance the same factors that Congress was balancing, or the same factors Congress told the agencies to balance. And if that's unconstitutional, then we can't possibly have a modern government.
Thank you, David. Thank you all. Appreciate those comments. We're getting questions pouring in from the audience, so I'm actually going to start fielding a few of those, but stemming from this question and where essentially the decision-making authority would be centralized. One of the questions we've gotten focuses on a very important element, that we are a nation of cooperative federalism. So we would appreciate any thoughts and comments on how you anticipate a change in deference impacting cooperative federalism and the relationship between, say, federal EPA and state environmental programs. And Steph, I'm not sure if you'd be like to take a first comment on this, considering you've been looking at changes in the role of deference, obviously, at the state level already.
Yeah, so I think that in a way, it's going to create a lag, right, in cooperative federalism. If every time a regulation is promulgated that involves some kind of cooperative federalism, for example, issuing permits for Clean Water Act point source permits, right? If there's a change in regulations on the federal level in terms of issuing discharge permits, and then the states are going to have to implement that, they're going to be in sort of a standstill, right, until the federal kind of question gets resolved, right? And so that's going to, I think, create a huge lag in sort of cooperative federalism implementation, even if and then this is also going to happen given the amount of, I guess, state federal litigation. It's going to happen strategically, right? There might be certain states that do want to actually implement the regulation, but they're going to be hamstrung by certain states that don't want to implement the regulation, and then they're going to there's going to be a whole dust up about that. So I think it's going to complicate things.
I appreciate that, Steph. Is anyone else like to weigh in on this point?
Yeah, I'm at the risk of talking too much, but you see this a lot in the Sackett case, that the justification for Alito's cramped reading of the federal scope, the scope of the Wetlands Authority, is that somehow, you know, the Federal Clean Water Act is an intrusion on the prerogatives of states. Well, I thought we had established back in the New Deal and then certainly in the 60s, 70s era that the federal government has the authority to regulate these polluters itself directly. And in fact, it does under the Clean Air Act in many provisions. There's no state involvement in regulating the car industry, the auto emissions, none in the hazardous air pollutant program, none in the new source part of the new source of the other performance standards program. And it's a matter of sort of convenience and a bit of a talking point that Congress, which in 1970 was taking away taking away state primacy in meeting the air quality standards. They said, well, we're going to develop cooperative federalism. We'll set the standards, and you will have first dibs on the opportunity to write the plan to meet the standards. And you don't have to. We can't make you, the state, do this. But if you don't do it, we'll write a federal plan. And this kind of cooperative federalism is implicit, in many kinds of statutes, including, for example, the Affordable Care Act. And what you see now is this red state pushback against that, where, in fact, in the West Virginia case, there was a brief trying to redefine cooperative federalism as the federal government has to cooperate in whatever the states want to do or don't want to do. Actually, Chief Justice Roberts' opinion reinforced that this is a federal responsibility. And the feds can tell the states, well, they can't tell them what to do, but they can set the terms for an acceptable state plan and then enforce a federal one if the states default. So if that's at risk, then, we're sort of headed back from the United States is to the United States are, which I thought we left that, we crossed that Rubicon in 1860.
Thank you, David. Yeah. I'm gonna switch over to a couple of questions asking for you guys to hypothesize. And one person noted this in their question explicitly, and I will say it writ large. No one will hold it against you if you get any of these things wrong. But in general, if Chevron is deemed unconstitutional, do you foresee that Congress will need to increase their hiring and consulting for scientific or technical expertise? So do you think that one path forward would be more congressional deference to scientists or technically those with holding kind of technical or specialized expertise during the lawmaking process itself?
So I'll go first. And I think this relates to the question also about the Congressional Research Service. There is, consulting. There's a body that does inform Congress on the science, and they are, they're great, but they are also understaffed. And to the extent that an increase in staff would help, I would welcome that. However, here's the problem with this, right? There's nothing that mandates that any congressional member or committee actually consults with the Congressional Research Service. The Congressional Research Service was actually modeled on a similar thing from Wisconsin, so I have to do another shout out to Wisconsin. The Wisconsin Legislative Reference Bureau, which was the model for the Congressional Research Service. And they're great, but they are understaffed. If they were more staffed, that would not require Congress members to actually consult with them. It's similar with the Federal Judicial Center, which also does a lot of both scientific and legislative and legal research for members of the judiciary, but the members of the judiciary do not often consult with them, nor do they even attend the orientations. And so there's a sort of voluntariness element to it that is absent from actually sort of agency decision-making, where they are bound by the administrative record. And so there's a sort of mandatory consultation with all the experts involved in a particular thing. Some might actually, there's also a strategic element to this, right? For those congressional members who are opposed to regulation in general, they might also strategically oppose additional funding for these types of consultants, so that no kind of consensus can be reached that provides all the particular sort of details. And so there's a strategic element to that I think would play out if Chevron is gotten rid of and it's all just about Congress having to anticipate everything that's going on in designing new laws.
Thank you, Steph. And Kevin?
I'll just say the question presupposes that we have a functional Congress, and that narrative, and that's part of Gorsuch's narrative, is that if you take away this authority for agencies to fill in the gaps, you will actually hold Congress's feet to the fire and require them, as those who are accountable to the electorate, to make hard decisions and to legislate. And I just don't quite buy it in this day and age when we can barely keep our government funded. And maybe we could roll things back to the era that David talks about, when bipartisan legislation has occurred. But that's what was part of the argument, is Chevron has been undergirding how laws have been written for 40 years. And it truly, that's why it deserves respect as stare decisis, because this is the way the legislature has functioned. And so the idea that you could just pull it away and say, get at it, Congress, start writing all those details, is one that I just don't quite buy.
Thank you, Kevin. Holly?
I would just add to that I completely agree with what David said earlier, which is that even at least as I heard it, even at its most functional, Congress could not possibly provide all the details and all the updating that's needed in many areas of modern law. And we're nowhere near the most functional Congress, given the degree of polarization, the degree of performative politics these days, and also just really practical things. Congress is in session for almost no days in the modern Congress.
Thank you, Holly. I'm going to switch a related question, David. Hopefully this will tie in. So one of the questions is, regardless of the outcome in these cases, would it be beneficial, and Kevin, this is going to pull in your reference earlier to the presumed dormant kind of non-delegation doctrine, but would it behoove Congress to explicitly state in legislation that they recognize that things are going to change, evolve, that maybe not all knowledge is already obtained, and that agencies will be required to respond, etc.? Can you get around delegation by being explicit about it?
Well, I do think that it would be easier for the court to come down against delegation by silence than it would be to, say that it's not even legit to delegate expressly like you were talking about. So, I can see an argument, and it was made in the lower court decisions and in lower court litigation in these two fisheries cases, that, if you use the traditional tools of statutory construction, you could conclude that Congress expressly authorized the charging of the boat owners in some circumstances and was silent on the rest. And that could be construed as withholding that power, not as just leaving it to the agency. There was also an interesting analogy in the First Circuit opinion about, well, who would argue that publicly traded corporations, who would argue that they don't have to pay for their CPAs that do the annual audit? Of course they do. I mean, and then that was maybe not even needed to be stated because it was such an obvious background proposition that you pay for your accountants, just like you pay for the hardware that you'd have to put in the stack of a smokestack to measure what's coming through. Anyway, I could see something coming out of this that is really more about reducing the deference by silence, the capacity of Congress to do that. But Kavanaugh, I think it was, maybe it was Gorsuch, seemed to say, well, look, if Congress says that one of the like the Federal Communications Commission should set a reasonable rate or an appropriate rate, that's a delegation. We get that. That's a positive decision. You could say in my original case, Congress didn't just use the term stationary source, it defined stationary source as 4 other terms, but it didn't define those 4 other terms. And it didn't say to the agency that you have the authority to define those, to further define those terms. And there are places in the Clean Air Act many places where it says there is an explicit delegation, for example, to recognize new pollutants that in the judgment of the administrator are determined to contribute to pollution that endangers public health or welfare. So I'm not convinced that there's a majority on the court to go so far as to say Congress has to do all that work. You could end up with even the most minimal would be to say, as Kavanaugh said in some of his writings, judges should not be so quick to defer. They should struggle more with the traditional tools to figure out whether there is a clear meaning here. Those would all be on the margins, but the attack on the ability of Congress to delegate and to say it has to do everything itself, that would be really serious. One last quick point. You could treat agencies as the advisors. In other words, the agency writes a regulation and it doesn't go into effect unless it's adopted by Congress. That's the REINS Act, I think. Problem with that is everything then becomes hyper-political. And there is some insulation from, the politics of financing campaigns and so on, from the fact that it's administrative agencies who make these decisions. And yeah, the president makes clear to some agency heads, I want to go this way to enhance my pre-electoral position, not that way, which would hurt it. But in some ways, if it was all down to congressional log rolling and lobbying and who's got the money, it's just another way of entrenching the powerful over the powerless.
Thanks, David. Kevin, did you have something to add here?
I mean, I think what I would just say is, as I try to explain this to my students who I'm teaching this quarter, that I don't think they're going to go there that far. I think when you look at the justices that now occupy the center of the court, Roberts, Kavanaugh, Barrett, I think they're likely to do something that, Kaiserizes, as they said, Chevron, like adopting the framework in Kaiser versus Wilkie, which dealt with our deference, which is an agency's interpretation of its own rules, and essentially saying, don't be too quick to find ambiguity and putting more checks on that. And, that's what the Solicitor General clearly was aiming her argument for, was, look, you can do that. And what the petitioners were saying, particularly in the Relentless case, is he said all these bells and whistles around Chevron, major questions, they're not good enough. They don't solve the problem. Chevron is the problem in and of itself. And also saying that, you really just get rid of that and that would take care of the problem. I don't quite believe that. I think what the center of the court was looking for was more, what do we replace it with? Is that more Skidmore deference? Is it more of these checks on judges and agencies when they're making these interpretations? And so I think we end up with, if it is overruled on the specific question presented about statutory silence can't be interpreted more broadly, I think that would be a problem. But to be honest, agencies have already been regulating upon the presumption that Chevron is not good law. And the court acknowledged that in their arguments, that nobody has been arguing Chevron recently in the court, and they certainly haven't been applying it because they know that there are these bells and whistles, this major questions doctrine. And agencies are being circumspect about their rulemaking, acknowledging that they're not going to get, as the conservatives would say, a thumb on the scale at step 2. So I ultimately think that we probably end up with a decision that, while it might hyperbolically seem like a really big deal, may not actually move the needle to the extent that I fear if this non-delegation constitutional doctrine is somehow inflected throughout it.
Thank you, Kevin. Appreciate it. So,
can I mention my biggest fear, which is that, at least listening to the arguments, there were so many different theories coming from the various justices about what their approach to deference and approach to separation of powers is, that my biggest fear is a completely splintered opinion where we don't actually know which is the narrowest concurrence, sort of a little bit like Rapanos, but maybe worse. That's my biggest fear. Hope it doesn't happen.
thank you, Steph. So I next would like to bundle together a couple of questions that get at the complexity of agency rulemaking today, both the number of steps and also how long it takes. This is not kind of a quick process. So the first question is essentially, when you're looking at all those steps and the amount of time involved, if you're looking at judicial review, right, that to actually decide whether that's permissible, if that comes at the end, we're talking about a huge time lag. If then you're starting that process again under a different interpretation of a different agency understanding of what their authority is. So the question is there a way, can anyone comment on whether there's a possibility, is there an option for getting that judicial review earlier in the process so that you're not getting to the end of a rulemaking before then you're considering whether you have that authority? So that's part one. Part two is, there are many steps. We've talked a lot about agency expertise throughout that process. There are also other things that are included in the rulemaking process, including a lot of participation and a lot of stakeholder engagement and kind of the voices of those affected. So if you could comment also on, is there an alternative for how that is incorporated into the process if it's not through the agency rulemaking? David, thank you for kicking us off.
Well, second part first. I mean, I think it's been a strong principle that an agency can't get deference if it hasn't aired the options that it's considering and taken comment and weighed those comments. I mean, that it's the need to take input is one of the essentials of deference, I think. And there's some of the opinions that, just agency pronouncements that came out of the blue don't get the kind of Chevron deference that stuff developed through full rulemaking does. Another point would be that, in the old days, and that means before my time, there was no pre-enforcement review. You wouldn't find out whether the rule was legal until you enforced it against somebody. And then all the issues that arise now at the point the questioner is, reflecting on, like at the end of this long rulemaking, they actually wouldn't come up until the 5-10 years later when somebody tried to enforce it. That's, I think, the Abbott Laboratories case. So we've been moving in a direction, I think, of having earlier answers than we used to get, and broader checks on administrative fiat, because there has to be public involvement and response to comments and so on. And I think that's a generally healthy way to run the governmental railroads.
Thank you, David. Would anyone else like to jump in on?
I would just add on this question about, with the agencies and all the process that they go through. It's another way that sort of the life and the world are inconsistent with the vision that's put forward by the hard right in their challenges to giving agencies any authority. I mean, this assumption that this statement that was made multiple times in oral argument, that if Congress, when it can't find a viable compromise, people who are pushing some agenda, go to their friends in the administration and get what they want from them. I mean, that's not the way rulemaking works, although it may be the way. It's more the right side of the political spectrum that wants it to work that way. This idea that the president is, kind of all powerful. As a factual matter, agencies are quite politically responsive in many, if not most, situations, and they have to hear all these different views through the notice and comment process. And David's absolutely right. They don't get Chevron deference if they haven't gone in general, if they haven't gone through notice and comment rulemaking. So in fact, in the modern rulemaking context, I would submit that the agency may be a more political branch, a more politically responsive branch than what we see in Congress these days.
Thank you. I appreciate that, Holly. Now, if it's all right, we're going to take a little bit of a turn. There's a few questions that have entered into the matrix that are looking at fundamentally the question. You can both standing kind of fundamentally and kind of the nature of kind of cases and controversies that led to kind of the taking of this case, as well as others recently. Is there anyone who would care to comment? Kevin, thank you.
I'll just say that this is a very different court than other courts. And, that's represented to some extent by the fact that they issued the decision they did in West Virginia, where they pronounced an already dead Clean Power Plan dead. The administration had already said, we're going in a different direction. We heard you when you stayed this rule court. We're going to start on a clean slate, they said. And the court nevertheless drove right by the argument, which was supposed to be about the lawfulness of the Trump administration's repeal of the Clean Power Plan. Instead decided, was the Clean Power Plan itself a lawful interpretation of the Clean Air Act? And that really reflected to me, there were mootness questions there, standing questions, that this is a court that is going to decide these tough questions, no ifs, ands, or buts. And I think that's reflected similarly here, that yes, the Fisheries Service may have refunded the monies that have been paid or stopped enforcing this, but that wasn't going to stop the court, wasn't going to deny the court its opportunity both to pronounce not on the merits, on how this case fits within its view of where it wants the law to go on administrative law, deference to agencies, the power of Congress qua the power of the courts.
Thank you, Kevin. Steph.
Yeah, so one thing that also struck me was that during the oral arguments, what came up was like, look, if the agency hadn't issued a regulation, but was just sort of engaging in some kind of enforcement action, wouldn't we have to do the interpretation of the law itself? Wouldn't a court have to actually interpret the law itself? And therefore, why have this sort of extra deference for rulemaking? And I was thinking, you know, a lot of times the way it comes up is not through, you know, federal courts, but first through an ALJ, right? Which the same court is trying to get rid of, the entire, you know, ALJ kind of system. And so, you know, it seemed a little, either it seemed like there was an actual disconnect or just a public disconnect between this whole, hey, we as courts visit this statutory interpretation issue anyway, when most times this would enter into an Article III court through some review of an ALJ administrative decision kind of record, where there would be a lot more fleshing out of the record versus just a court starting off with the regular rules of statutory interpretation. There'd be a much more large administrative record, much like a rulemaking, although different. And so I found that to be kind of striking in terms of the questioning, which also suggests to me potentially a bit of insincerity on the part of the court, given the status of ALJs right now before the Supreme Court.
Thank you, Steph. If there's anyone else? Okay. Then I'm actually going to offer up a comment that was submitted and to see if that triggers any further comment. This, I'm going to go ahead and read it verbatim. It's very well stated. In my view, there is a significant difference between Congress providing the big policy direction and having the executive fill in the regulatory structure by agency rulemaking about exactly what will be done. And on the other hand, a court deferring to an agency expert on a specific issue or in a specific case when there's an industry expert who is equally qualified. And they note that in their state, they've done away with the level of agency expert deference in administrative proceedings. So this question, we've been looking a little bit at the question of within government, kind of where the level of detail lies. And this is the question of the deference to an agency expert versus an industry, or should say a private sector or a non-governmental kind of expert. Would any of you care to comment or respond to that? David?
I think I'd just quickly say that I think that's a different question. That's a question of arbitrary and capricious review. It's when you get down to the level of, is this chemical or carcinogen or not? Is this exposure route demonstrated to occur or not? Those kind of factual questions, I hope, are sort of secure in arbitrary and capricious review. That you know, the environmental expert, the industry expert, the government's experts, they get the chance to make their factual case, and the government expert doesn't win because he or she says, I have a bigger PhD than you do. The government has to at least say, you know, these things are equally likely, or this is more likely than that. And even if this is less likely than that, the risk, you know, we put, if you will, a thumb on the scale of protecting human health. And anyway, that's the way we're going to go. And so the factual things are just got to be. It's very hard to get a government decision deemed arbitrary and capricious unless it's 2 + 2 = 12. But in a close call, you defer to the agency, and in part, and then when things like policy, like how do you weigh the relative value of protecting the person versus the relative cost on the company of the restriction? Those are policy questions. And I hope those are relatively secure, even if there's some um, uh, big change in Chevron itself.
Jordan, you're on mute.
Thank you. So there's another comment. Thank you, David. If anyone else would like to chime in. We're now getting to the time where we're going to have time for one or two more questions. And so I apologize. They're just absolutely fantastic questions in kind of the Q&A, and I apologize that we can't get to all of them. But I'll try and do a couple of slightly different ones. One is actually returning to the question of ambiguous versus unambiguous and what can Congress do? So there's a question focusing around the fact that, look, if we assume that we don't actually want ambiguous statutes, how do we try to get Congress and to pass unambiguous laws? So this is a little bit of stopping, not necessarily what is the exact response to Chevron, et cetera, but if the general idea is that we would like clear and unambiguous statutes, what are some tools for trying to get Congress to pass them?
I seem to have, other
Go
people
ahead.
first, but I have some thoughts on this. There's at least two kinds of ambiguity. There's the ambiguity that comes when I want X and you want Y, and we fuzz it up by picking some words that allow for the agency to choose between X and Y. And then there's another kind of ambiguity, which I think is the most pernicious, is that when Congress is actually trying to be clear. Like, who in 1977 would have doubted that what a stationary source was? It was a building, a structure, a facility, or an installation. Those four words connected by or. Congress is trying to give examples of the kinds of components that you would find in a factory. If they wanted to say a major stationary source is an entire factory and there can be offsetting, and there's only a major new source has been built if the net change in the pollution of that thing increases. That would have been that's the less expected thing. That would be the thing that if they wanted to say, they would need to say clearly. But normal human parlance back in the 70s, or what do we're not going to list all blast furnaces, boilers, and 75 other nouns. We're going to give four examples. And then afterwards, clever lawyer combatants start retroactively making words ambiguous. And that is a pernicious thing that's happened under Chevron. I mean, we got a lot of decisions moved to step two because of that kind of creativity. Allowed the litigants or the judges or the agency to escape the clarity Congress actually thought it was providing. One of my favorite anecdotes is, though, that shows how at the extreme this just wouldn't work. In the Clean Water Act, there's something called the total maximum daily limit. And at one point, I think it was the Reagan administration interpreted that to mean an annual average. And Judge Tatel wrote an opinion in which he said, look, there's some flex to the term daily. It could mean, midnight to midnight. It could mean some, rolling daily average. It can mean many things, but it can't mean an annual average. And that was just going too far. The trouble is many of the decisions, agency deregulatory decisions and maybe some pro-regulatory decisions get upheld with that kind of creative interpretation of words that Congress really didn't think they were, they really thought they had been clear about. Anyway, that's my experience.
Thank you, David. We are actually now at the final minutes of the panel. So I would actually like to ask all of you in closing, we'll just do a little round robin for you to either reiterate a point you've already made, or just what is one takeaway that you would like to offer the audience as we wrap up this discussion. I'm going to go through my order of boxes. Holly, you're first up for me.
Oh, wow. I mean, I think the key takeaway is we should expect the court to try to come up with a result that will further limit agency discretion. I'll be super surprised if they get to non-delegation here, right? But I think they are probably most likely to say courts be a little more careful, be more careful about Chevron deference. I really think the overall lesson that people have made this point a number of times is that Congress can't possibly do it all. And the courts should be humble enough not to try to demand that.
Thank you, Holly. Steph. Oh, you're muted.
I echo what Holly said. I think that the lack of humility is really striking, and it might not be lack of humility. It might just be not understanding how much knowledge there is out there. There's a tendency for lawyers to think that we can do everything, and we can't. And so, the breadth of technical knowledge that's necessary to create any kind of interpretation, much less see the future, is something that we should be sort of concerned about. And I didn't really hear that in some of the justices' questions.
Thank you, Steph. Kevin?
I would say that I just think it's important for us as lawyers to realize when we're doing these questions of statutory interpretation that we really need to think about these larger separation of powers, constitutional dimensions, and the political implications of any particular interpretation that we're either trying to defend or attack, because that's where the court has been going these days.
Thank you, Kevin. And David?
I would say agree with all those points, and say also that although it's not all wrapped up in one case, which I hope is going to be called Relentless rather than Loper Bright, but there's a broader attack on the power of, as I think Steph mentioned or somebody mentioned, administrative law judges, broader attack on powers that it is assumed that the federal government has since the New Deal. The goal of at least the litigations, the litigators, the interest groups that are framing up these cases, is to destroy modern government, is to destroy the capacity of government to, in a timely way, limit the freedom of action of, let's face it, of the powerful. And it's only if the middle of the court begins to push back and realize that, there's important interests in them, that these laws are intended to protect, not just that are intended to restrict, that we'll get some balance here. And so I have some hope that Roberts, Barrett, and maybe even Kavanaugh don't really share the same destroy modern government mission of the other three. We'll see. And I found that in West Virginia, and that the opinion, although as Kevin said, announces some very broad principles, it actually also sketched out a pathway that EPA, for EPA's legitimate, quote, traditional authority to regulate greenhouse gases. And then when Congress reacted with the Inflation Reduction Act, they reinforced some of those same powers, both with changes to the Clean Air Act and with a lot of money in the form of incentives to make regulation cheaper. So I think there are still pathways forward if the Chief Justice and a couple of the others, take a moderate approach instead of the radical approach.
With that, I would like to say an enormous thank you to all of our speakers today. David, Steph, Holly, Kevin, thank you very much for making time and space for this conversation today. I would also like to say thank you to our team at ELI, especially Madison Calhoun and Sarah Vikan for organizing today's events. And finally, to everyone who tuned in, to everyone who listened, took time out of your day, to everyone who submitted questions, which we will download and provide to the panelists in general. Thank you so much for taking this time, making this space to learn about this potentially impactful decision. I hope you enjoyed it. I hope you learned from it, and I hope to see you at events in the future. In the meantime, thank you, and please all take care.